All right, then, here's a question for you. Is art created by AI just plain old plagiarism by another name and maybe perhaps a little bit of fancy packaging? That is a question that is being asked in increasing frequency in legal and tech circles after a month in which new algorithms have exploded into the public domain, creating images and pictures in very different styles. Stability AI, a London-based firm founded in 2019, is facing two legal challenges that could inform how this plays out. The first is from the photography firm Getty Images. It's accusing Stability AI of breaching IP laws by copying and processing millions of images protected by copyright to the detriment of its content creators and without having acquired a license to do so. The second lawsuit has been filed by artists who are accusing the firm of doing largely the same thing, using their work without their permission to train their algorithms, which then create art in a similar style. A little earlier, I spoke to the chair of the Copyright Tribunal here in Kenya, Liz Lenjo. I started our conversation by asking her, in cases like these, where does ownership of machine-generated art lie? Put another way, if a program learned to create art with your pictures or your selfies, do its programmers owe you a cut of any revenue they make?
It always starts with who created it to begin with. And a machine cannot do anything a human has not done, right? So which means the initial copyright holder would be the person. And then now it would transfer to a company if that person is hired by a company and they sign a contract, what we call a work for hire agreement, or some sort of a sale agreement where they sell their copyrights in the work to this particular company, then the company would own it. So intellectual property ownership in general, copyright ownership has to vest in a person and then a company subsequently by way of a contract.
Okay, so I guess that the problem here with the way this story is playing out is, you've got artists here who are saying, hang on, we've built up this body of work over 10, 15, 5 years, whatever the period of time is. I'll put it online, it's available on the internet. And someone has then created a program that has essentially scraped that information, uses freely available data to then create an art style that imitates that. In that sort of context, do the artists have a case?
I think they can, as long as you can prove access, as long as you can prove what we call substantive or substantial similarity or objective similarity, then you can. And what we are seeing a lot with these machines and these platforms is that you will see they always, in the metadata, they will make reference to a certain artist or a certain creative, I don't know, I guess to pull clout, but at the same time, you can argue that they're indirectly attributing the original author.
Arguably, you're seeing a lot of things that, will come up in this sort of context. Artists like those entitled to turn around and claim compensation, because the defense that some of these AI companies are using is saying, hang on, yes, we might have used this as learning material, but what our programs are creating is entirely different. And therefore, you as an artist are not entitled in any way, shape or form to any kind of restitution.
Well, in copyright, we have what we call the right to control derivative works, which means that, I have the right to decide whether I can give my work out there for someone to create something off of what I already have. And if they do, then two things must happen. They must seek my permission, and I must give that permission in writing. And of course, I have to be compensated. So it has to be on my terms, because copyright grants the exclusive rights to control, which includes reproduction. It includes the right to to control derivative works or access to derivative works. It includes distribution. So at the end of the day, you cannot, take away those rights without, speaking to the author themselves or getting that permission from the author directly.
Indeed, and I know you've been putting in quite a bit of work behind the scenes on getting the Copyright Tribunal regulations up and running. But I just want to use this hypothetical scenario that we tend to see a lot, especially in the tech world, to see how that might be handled within Kenyan law. You have a situation here where companies will say, we are essentially going to be using, to some extent, by accepting these terms and conditions, we might end up using some of the information you upload to our servers to train machine learning models of our own. And that has been the case. Most of us just essentially hit agree, and then we get on to using the software that we have in hand. But in this sort of context, with disputes like these arising, that has to change, doesn't it?
Definitely, because at the end of the day, for example, a tribunal in our instance would be examining the intention. It would be also examining the issue of access. It would be examining the issue of fair business practices. Like a lot would come into play, and then to be sort of a balance at the end of the day. But in the strict sense, when you sign a contract, it means that despite you having not read it, you are bound by the fact that you just clicked I accept. You are automatically bound. So, and that's why we are always telling people you need to read these terms and conditions to understand the impact that a particular platform would have on your intellectual property. If not, then at the end of the day, you're sort of hanging on a balance. At the end of the day, it will depend on what the case made by the other party on the tribunal. Again, like for us in Kenya, we're talking about a copyright tribunal. So again, for us, we would be restricted to looking at the matters copyright. Is there an infringement? Is there a consent, for example? Was there any transfer? Those are the things then the tribunal would be looking at.